In this lesson, we're going to talk about the next of our major principles of the UK Constitution, arguably the most important principle, and as a result of which, the one that we're going to spend a lot of time examining. This is the idea of parliamentary sovereignty. So we'll talk about parliamentary sovereignty in a number of different ways in the next few lessons. We'll talk about a sort of general principle in this lesson, as well as talking about the history in the next lesson, looking at some of the ideas enrolled within the idea of parliamentary sovereignty, so things like the doctrine of implied repeal, for example, and then talk about challenges to parliamentary sovereignty, at least challenges on paper to the idea of parliamentary sovereignty. We'll do that towards the end. Arguably, and in my opinion, probably, the doctrine of parliamentary sovereignty, the principle of parliamentary sovereignty, is the most fundamental and important of all of the principles that exist within the UK Constitution. We're going to be spending a lot of time talking about this principle. We'll talk about the original position of parliamentary sovereignty, take an introduction to parliamentary sovereignty in this lesson. We will talk about the historical development of the doctrine of parliamentary sovereignty, so talking about the pre versus the post 1688 approach to parliamentary sovereignty, where you have in the pre-stages, the preliminary stages of the idea of parliamentary sovereignty, there is a lot of judgment that suggests that the common law may actually be supreme and that the parliament may be subordinate to the common law. And then you have the 1688 Glorious Revolution and the subsequent 1689 Bill of Rights, which enshrines this principle of parliamentary sovereignty as being the most foundational of the UK Constitution. We'll talk about parliamentary sovereignty today, talk about the idea of the enrolled bill rule, talk about the idea of implied repeal, talk about the theory of constitutional of the Constitution relating to parliamentary sovereignty. And then finally, we will talk about challenges to parliamentary sovereignty. And we can explain challenges to parliamentary sovereignty by reference to a number of different institutions, different principles, and different laws, which may be said to present something of a challenge to the idea. So our previously existing membership to the European Union is something of a considered to be challenge to parliamentary sovereignty. The idea of devolution is considered to be a challenge to parliamentary sovereignty. So too is the Human Rights Act from 1998. So we've actually already talked about parliamentary sovereignty quite a lot in this series of lessons already. So I'm going to be quite brief in explaining what parliamentary sovereignty is in its general form, because ultimately what this tells us, what the principle of parliamentary sovereignty tells us, is that the Westminster Parliament, the Parliament that we can see just above the screen here with Big Ben in the picture, is the supreme lawmaking authority in the United Kingdom. That is all parliamentary sovereignty tells us. Okay. Now there are various other elements that are attached to it, which we'll get to in a second, but fundamentally, the concept of parliamentary sovereignty is that the Westminster Parliament, the Parliament that is situated in Westminster, is the supreme lawmaking authority in the UK. So it also means that Parliament has the complete authority to make and unmake any law it so chooses. And this represents the cornerstone, in my opinion at least, the cornerstone of the UK's constitutional framework, because it establishes the highest authority of lawmaking in the United Kingdom. So rather than there being some codified constitution where you have an entrenched principles of law that are difficult to amend with a single constitutional document like you have in the US, for example, where the highest law and the highest lawmaking authority is represented and enshrined by the US Constitution, what we have is a principle, and this is the principle of parliamentary sovereignty. This represents the highest establishment of law and legal authority in the United Kingdom, rather than the idea of a single codified document. And it ties into a little bit what A.V. Dicey says about the rule of law, the idea that the ordinary law is supreme. The idea here is that the law that is passed here by Parliament is supreme. It is the highest authority in the United Kingdom. According to A.V. Dicey specifically, in fact, who talks a lot about parliamentary sovereignty, neither more nor less than this, namely, the Parliament thus defined has, under the English Constitution, the right to make and unmake any law whatsoever, and further, that no person or body is recognised by the law of England as having a right to override or set aside the legislation of Parliament. This is essentially the enshrining of the principle of parliamentary sovereignty by A.V. Dicey specifically. And what in fact A.V. Dicey is doing is outlining two elements to the principle of parliamentary sovereignty. And it is true that these elements exist. The elements are that parliamentary sovereignty can exist in a positive sense, in a positive legal sense, but it can also exist in a negative legal sense. There are two elements attached. The positive element is the fact that Parliament has the power to make and unmake any law they so choose. They have the active authority to go and they can pass a law that says whatever they want, okay? But they can also take laws away if they so choose to. If they think, you know what, tomorrow we don't want the Companies Act 2006, we're going to get rid of it. They can. They absolutely can. Can they say, tomorrow we're going to pass a law tomorrow that says that it is now legally acceptable and legally permissible for you to punch your neighbour? Absolutely. There is nothing legally, shall we say. Legally, there is nothing that suggests that Parliament does not have that power to do so, because there's no other higher authority that limits Parliament in that way, at least theoretically, at least on paper. The negative element relates to other institutions which relate to Parliament. So no other person or body is recognised by the law of England as having the right to override or set aside the legislation of Parliament. So not only does Parliament have the positive right to make and unmake any law they so choose, but they also have the right to be supreme. They have the right to be supreme in relation to any other institution, such that no other person or no other institution can override and set aside legislation that is passed by Parliament. Now, from a historical perspective, we will get to this in the future, in the next lesson, should I say specifically, but the doctrine of parliamentary sovereignty develops mainly out of the civil wars and revolutions in England, with the execution, the regicide of Charles I, the restoration of the monarchy, as well as the invitation of William of Orange with the Glorious Revolution of 1688. We'll get to more of this in the next lesson, but ultimately, while these are the sort of impetus catalysts for the formal enshrining of the principle of parliamentary sovereignty, the idea and the relationship between Parliament and the monarchy had been straining very slowly for many years prior to the events which takes place under the early period of the Stuart dynasty. We'll get to all of this though in the next lesson. In the previous lesson, what we did was introduce the concept of parliamentary sovereignty. This lesson I want to essentially talk about the history of this principle and explain how it develops out of the period of the Stuart dynasty within Britain, and then talk about how modern conceptualizations of the principle exists to this day. So, like I said, the previous lesson introduced the subject of parliamentary sovereignty, we outlined its meaning, and then also we outlined a number of the implications that exist therein. So, for example, the concept of parliamentary sovereignty being both a positive and negative set of obligations on the part of the fact that Parliament, from a positive sense, can make and unmake any law they so choose, but they also have this fact that we have a negative element of sovereignty, which suggests that other institutions and organisations have to always regard parliamentary legislation, and they can never disregard and ever set it aside. This lesson, like I've said, is going to explore the historical development of this principle and examine how it applies to this day. Now, beginning first then with the early history of the principle. In the earliest of history of England, we see that the concept of parliamentary sovereignty, or at least the concept of sovereignty, where power lies, was something which was exercised by the sovereign, him or herself, this being the authority of the Royal Council, and that this is really where we see the authority of lawmaking beginning in the history of England. The council, the Royal Council, or the Cura Regis, would develop into the creation of the first parliaments, and that these first parliaments would lead to the establishment of a formal legislature throughout time. The understanding of how Parliament is structured today, in fact, comes out of what is known as the Model Parliament in 1295 under Edward I. This was where we see, firstly, the division of Parliament into two branches. So you have the idea of bicameralism actually beginning in 1295 under Edward I. You have bishops, abbots and barons forming the House of Lords, and then you have 2 knights from each shire forming the House of Commons. This is the model parliament of 1295. In 1539, Parliament passes the Statute of Proclamations. So we see a significant period of time where we see Parliament essentially being subordinate to that of the Crown, being called by the Crown to pass legislation, often for financial purposes. 1539 is a year where the monarch in England was Henry VIII. Henry VIII would rule England from 1509 to 1547, and in 1539 Parliament passes the Statute of Proclamations. This gave the king at the time, as I mentioned, Henry VIII, the broad powers and the broader authority to essentially legislate without reference or consent from Parliament. One of the historical traditions that existed with monarchies even before Henry VIII was this idea that you would call Parliament to legislate, and you would require the consent of Parliament to legislate. In fact, this was one of the most significant influences that Henry VII attributed to his consolidation of authority and royal authority. His claim to the throne was very, very weak in comparison, and so to end the Wars of the Roses in 1485, what Henry VII did was call Parliament to ensure his royal authority. Okay. And so ultimately, this is a tradition that becomes a little bit skewered with his son Henry VIII, because in 1539 we see the passage of the Statute of Proclamations, differing, like I said, from his father Henry VII, who believed and regarded the requirement that Parliament be required for the passage of legislation. In 1610, then, when we see a transfer in dynasties away from the Stuart period, with the death of Elizabeth I in 1603, and we see James I becoming the first Stuart monarch, we see the case of the Dr. Bonham's case. In this case, the Lord Justice Coke would ultimately establish the rule which seemed to contradict any idea of parliamentary sovereignty. So remember, this is before parliamentary sovereignty becomes an established and enshrined principle. Because in this case, what Coke essentially does is suggest that the common law is sovereign, and it is Parliament that is subordinate to the common law. Coke noted that the common law may be able to control the power of Parliament, and even declare provisions were void if they were against common right and reason, or repugnant or impossible to be performed. What this is doing is essentially enshrining the idea that it is the rule of law which is the authoritative principle of the UK Constitution, or at least the British Constitution, and that this idea of parliamentary sovereignty is subordinate to the rule of law, owing to the fact that the rule of law essentially allows for parliamentary decisions or parliamentary legislation to be set aside if it is repugnant or impossible to be performed. The ultimate conclusion that we see here is that the English Civil War changes all of these processes quite significantly. This is one of the most fundamental power struggles that existed, and really it was a question of where we see power lie. The supporters of Charles I, the Royalists, argued that that sovereignty laid in the hands of the king, and that sovereignty was delegated by the king with the express permission of the king to Parliament. The Parliamentarians, the people who supported Parliament, as you can probably imagine, believed that sovereignty lied with Parliament, acting on behalf of the people. Ultimately, this is what the English Civil War was about the fact that Charles I would continually try to raise taxation and try to raise finances from Parliament, and that then would ultimately cause a lot of division and disputes between the two sides, between the Royalists and the Parliamentarians. Again, the main issue was where the power of taxation lied. Charles I would often exert his right to issue new taxes, and would do so without the consent of Parliament, shall I say. Even though the remit of Parliament and the fact that taxation was a provision and a competence made by Parliament was something that had been established all the way back in the 1200s with the reign of Edward I. Without divulging into too much detail about the English Civil War, the regicide of Charles I, and the back and forth and the restoration of the monarchy, we see that we get the restoration of the monarchy, but then we get a new monarch who is invited in, because James II, who is ultimately who is ultimately replaced by William of Orange, we see this with the 1688 Glorious Revolution. Okay, so when the reign of James II, who was a Roman Catholic, would come to clash with that of Parliament, we see that Parliament decides, very prominent politicians would actually sign a letter inviting the son-in-law of James II, who was really William of Orange, who was a Protestant, to come and take the throne. And so William of Orange would do so, and was met with very little resistance, and a convention parliament was called in regard to this particular invitation. Ultimately, his invitation to reign came with a number of conditions, one of which was an acceptance of the 1689 Bill of Rights. And the significance of this was the fact that essentially what it asserted was that the rights it asserted the rights of Parliament over the monarch and his wife Mary II. And ultimately, we see in 1689, the Earl of Shaftesbury state that the Parliament of England is the supreme and absolute power, which gives life and motion to the English government. And this essentially is enshrining, in 1689, the year of the Bill of Rights, the year after the Glorious Revolution, a fundamental shift in where Parliament lies in the broader structure of authority. Parliament lies at the top. Parliament is sovereign as a result of these events that take place. So this is really where the history of parliamentary sovereignty ultimately begins to take shape and becomes the most prominent principle of the UK Constitution. In the next lesson, we'll sort of do a little jump to the more modern conceptions of parliamentary sovereignty and talk about some of the principles of parliamentary sovereignty. So in the previous couple of lessons, we've been talking about the principles of the UK Constitution. We've explored the idea of the rule of law, we've talked about the concept of the separation of powers, and we've been spending a lot of time talking about the concept of parliamentary sovereignty. Now, the principle of parliamentary sovereignty is arguably one of, if not the most important of the basic principles of the UK Constitution. Now, constitutional scholars will maybe disagree with me in that regard. Some may say that the rule of law is more important. Others may say that the idea of the constitutional monarchy is more important. But I would wager that arguably the most important principle of the UK Constitution is this idea of implied repeal. This idea of parliamentary sovereignty. And we've been talking a little bit for the last 2 or 3 lessons about the doctrine of parliamentary sovereignty. And this lesson is going to talk about one of the contingent elements of parliamentary sovereignty, which is this idea called implied repeal, as I've been constantly trying to stop saying at the start of this lesson. So we're going to explore some of the underlying principles relating to the principle of parliamentary sovereignty, almost described as almost subsidiary elements of the principle of parliamentary sovereignty. We'll spend most of our time examining the doctrine of implied repeal of legislation. What does the doctrine of implied repeal actually tell us about the nature of sovereignty of Parliament? Well, it is one of the most important elements of the doctrine of sovereignty that Parliament today will not be able to bind successive parliaments in the future. This suggests that the concept of parliamentary sovereignty is one which is temporal in nature, the idea being that future parliaments cannot be limited and restricted by parliaments of the past. And this suggests that, therefore, because of this, there would be a limitation on parliamentary sovereignty of future parliaments if this would be allowed. And one of the ideas that is representative of this is this idea of implied repeal. The idea that Parliament cannot bind successive parliaments in the future means that Parliament cannot pass a single piece of legislation which would subject future parliaments against their will to it. It suggests that any future parliament can repeal and replace any of the parliamentary legislation that is passed in this parliament or parliaments before. And this is one of the interesting elements of parliamentary sovereignty. It doesn't suggest, therefore, that you can't pass legislation which may have some kind of political binding authority. Some argue that things like the Human Rights Act is relatively strong and stable in its ability to bind politically future parliaments because of the fact that it is so foundational and constitutional in nature that it suggests, therefore, that it would be very politically disadvantageous to try and abolish the Human Rights Act. But the idea here is we're not talking necessarily about the political elements of parliamentary sovereignty, we're talking about the legal. And in the context of the legal elements, there is no mechanism which is limiting the ability for Parliament to repeal and replace the Human Rights Act. Now, Parliament has the ability to expressly repeal whichever piece of legislation it so chooses. If Parliament passes a piece of legislation in the future that suggests the repeal of previous legislation, that is perfectly within the remit of Parliament to do so, and perfectly within the remit of parliamentary sovereignty to do so. For example, if Parliament was to pass legislation that expressly repealed the House of Lords Act or repealed the Companies Act, for example, it could do so, and those pieces of legislation would be no longer binding. But what about this idea of impliedly repealing something, using implied repeal? Well, the idea of implied repeal is that where you essentially take a future piece of legislation and you have that legislation contradict previous legislation. The doctrine of implied repeal tells us that owing to the idea that Parliament doesn't bind successive parliaments, the future legislation has impliedly taken away and impliedly repealed the earlier piece of legislation. That is what implied repeal tells us. So where there are two pieces of legislation which seem to contradict each other in some way, the traditional view is that the more recent legislation will have been impliedly repealed, and the legislation that existed previously will no longer be in effect, and it would have been replaced by the new future and more up-to-date piece of legislation. So as such, the previous legislation cannot protect itself from being repealed in the future. If you had a contradiction between two pieces of legislation, it is always the most up-to-date and most recent legislation that is going to take precedent. The reason for this is, of course, the fact that Parliament cannot bind future parliaments. And if you had two pieces of legislation, one that was being passed today and one which had been passed 20 years ago, and you had a situation where the earlier legislation was the one that took precedent, then that would imply that the previous parliament that existed 20 years ago could bind the wills and the wishes of the future parliament that is passing legislation today, which is of course not allowed. And one example of how this has been illustrated in the case law is in the case of Vauxhall Estates Limited versus the Liverpool Corporation from 1932. The compulsory purchase of housing took effect as a result of a piece of parliamentary statute. Where there was the compulsory purchase of housing, there was the ability for the previous owners of that purchased housing to gain some form of compensation as a kind of remedy for the compulsory purchase of said house. Now, there were two pieces of legislation, both of which outlined the regulation of this compensation scheme. The first of which was the Acquisition of Land Act from 1919, and this used an open marker method of compensation. You don't need to know necessarily what this actually entails, but you should just know that these are two different pieces of legislation which regulates the concept of compensatory remedies for the compulsory purchase of housing in different ways. The second piece of legislation was the Housing Act from 1925, and this used a value assessment on the basis of the, quote, land as a site cleared of buildings. Both different ways in which you can calculate and use and essentially conceptualize the concept of compensation, and both pieces of legislation that essentially provided regulation of compensation over the same area of industry and of the compulsory purchase of housing. So you would think, okay, well, what happens here is there is a contradiction between the two pieces of legislation. The previous legislation, too, also sought to protect itself from reform by providing that, in Section 7, subsection 1, if there was a legislation which was inconsistent with the Act, it would have no effect. So not only is there two pieces of legislation, both regulating the same area of law, but are contradictory against each other, but the earlier piece of legislation attempted to try and protect itself from reform by suggesting that anything that contradicts the Acquisition of Land Act from 1919 will have no effect. So if we were to apply this piece of legislation, if we were to apply Section 7, subsection 1 of the Acquisition of Land Act, it would mean that the 1925 Housing Act would have no effect, owing to the fact that Section 7, subsection 1, meant that it would render any future legislation void if it was inconsistent with the Acquisition of Land Act. The issues here are very easy to see. The question was, for the court, A, whether or not the 1919 Act can have this prospective binding effect, i.e. whether or not subsection 1 of Section 7 was actually legal. And then secondly, the question of, okay, well, if that is the case, or if that is not the case, what is the piece of which is the piece of legislation which should take effect? Which of the two should take effect? Now, you should know already the answer to both of these questions if you have been listening to my conversation about implied repeal. Ultimately, it was held that the Housing Act of 1925 had impliedly repealed the Acquisition of Land Act from 1919, or specifically the provisions relating to compensation, and this was the case owing to the contradiction between the two pieces of legislation. As such, the more recent piece of legislation took effect, and Section 7, subsection 1 was null and void, owing to the fact that it would be a violation of parliamentary sovereignty. The final thing I want to talk about in relation to implied repeal is this idea of how this operates in relation to the law of the European Union. Because, of course, even though we are no longer members of the European Union, the concept of EU law was very much a substantial element of the UK's constitutional framework going back to the 1970s when we joined. According to Section 2, subsection 4 of the European Communities Act, 1973, it says that the provision that may be made under subsection 2 above includes, subject to Schedule 2 of this Act, any such provision as might be made by Act of Parliament, and any enactment passed or to be passed, other than one contained in this part of this Act, shall be construed and have effect subject to the foregoing provisions in this section. Essentially, what this provision is telling us is that while the UK was a member of the European Union, the concept of implied repeal seemed not to apply to the application and implementation of EU law. We will get to the concept of EU law in the future as a challenge to the traditional view of parliamentary sovereignty, but for now keep in mind the idea that there are elements of the UK's constitutional framework which did, and still to this day does, present something of a challenge to the concept of this traditional view of sovereignty. In previous lessons, what we've been doing is talking about the various different principles of parliamentary sovereignty. For example, in the previous lesson, what we did was examine the idea of implied repeal as an essential element of the principle of parliamentary sovereignty. Well, what we're going to do in this lesson and in the next lesson is talk about some of the quite substantial challenges that have been presented and levied against the traditional view of parliamentary sovereignty. This will involve talking about, in this lesson, parliamentary sovereignty in relation to the law of the European Union, and then in the next lesson we'll talk about parliamentary sovereignty in relation to the Human Rights Act. So these are going to involve essentially an exploration of the implications relating to the traditional view of parliamentary sovereignty. And the traditional view of parliamentary sovereignty is arguably challenged by these basic principles of the UK Constitution, such as membership towards the European Union, as well as membership to the European Convention on Human Rights, and the subsequent domesticization, if you will, of that particular convention with the passage of the 1998 Human Rights Act. So, one of the things I want to do as a basic overview is talk about the concept of sovereignty in relation to membership towards the European Union. Even though we are no longer members of the European Union, it is still a very important and applicable element of parliamentary sovereignty, owing to the fact that we were members for over 40 years. The concept of legislative supremacy and the implications that legislative supremacy has for the law of the European Union has been seen and can be seen when we look at the various different clashes that existed between the European Communities Act 1972 and legislation which has passed since the enactment of this particular piece of legislation itself. So, we remember from the previous lesson in case law and in just sort of general constitutional theory. Now, the doctrine of implied repeal tells us that if there is a contradiction between two pieces of legislation, then it is necessarily the latter that takes precedent over the former, owing to the fact that Parliament cannot bind its successors. But when you see things like the European Communities Act, you have to think about how this relates to the doctrine of implied repeal and therefore the principle of parliamentary sovereignty. So, on the traditional view of parliamentary sovereignty, as well as the general implications that this has, which is, of course, the doctrine of implied repeal, if a piece of legislation is passed by Parliament, and that piece of legislation contradicts the European Communities Act from 1972, then it is this legislation that is to be repealed, not the legislation which comes after it. However, the case law is taking a very different view on this matter, in fact completely rejecting the concept of implied repeal in favour of the piece of legislation which is the European Communities Act itself. Now, arguably the most important case in this regard is the Factortame case, the second one, which is the R and the Secretary of State for Transport from 1991. This case involved a number of companies under the moniker F and others, which were incorporated in the United Kingdom. They were incorporated under the legislative and general legal principles of UK company law. They had a number of deep-sea fishing vessels which were registered, again under UK law, under and in conjunction with the Merchant Shipping Act of 1894. And this was the case despite the fact that they were operating almost entirely out of Spain. So their actual operational location, shall we say, was not in the United Kingdom, but in fact was in Spain, despite the fact that they were both companies that were registered under UK company law, and the fishing vessels were also registered under the Merchant Shipping Act of 1894. In 1988, the government would pass a new Merchant Shipping Act, one which required that all UK-registered vessels needed to be at least 75% owned by UK residents. So this presented something of a challenge for these companies, given the fact that they were operating entirely out of Spain, or almost entirely out of Spain, but they were still registered and had registered vessels in the United Kingdom. It was argued that this was a violation of community law, that being the passage of the 1988 Merchant Shipping Act, owing to the fact that within the European Union, specifically within the Common Fisheries Policy, the CFP would allocate quotas for each country, and that having UK residence requirement was tantamount to discrimination on the basis of nationality. It was held by the European Court of Justice, the Court of Justice for the European Union, in the first of the Factortame cases from 1990, that domestic courts need to grant an interim relief in order to protect EU law, and as a result of which would disapply any national law which conflicts with the general principle of community law and the Common Fisheries Policy. So we have some issues here. There was seemingly a conflict between both EU law and the Merchant Shipping Act of 1988, should I say, but also, as a result of this fact, there was a conflict that existed within the domestic constitutional framework of the United Kingdom between the European Communities Act and the 1988 Merchant Shipping Act, owing to the fact that the European Communities Act legislates that all community law be applied in the United Kingdom's domestic framework. So, the traditional view of parliamentary sovereignty and the traditional understanding of the doctrine of implied repeal would suggest, therefore, that in order to alleviate this problem and to remedy this situation, it is the European Communities Act which gets repealed owing to the conflict that exists between the 1972 legislation and the Merchant Shipping Act from 1988. The Merchant Shipping Act was in violation of EU law as a result, and this was what was held by the courts, and so as a result of which interim relief would be granted to allow the disapplication of the Act. The European Communities Act, as a result of which, had expressly given EU law supremacy in its application to the United Kingdom. Parliament had entered voluntarily into the European Union, and they did so through referenda as well, should be noted, and so this did not represent a limitation on the doctrine of parliamentary sovereignty. They say here that whatever limitation of its sovereignty Parliament accepted when it enacted the European Communities Act of 1972 was entirely voluntary. Under the terms of the 1972 Act, it has always been clear that there is a duty of the United Kingdom Court when delivering final judgment to override any national law found to be in conflict with any directly enforceable rule of community law. So as a general commentary, therefore, what does this mean for the doctrine of implied repeal? This passage seems to ultimately take a different view to the principle of implied repeal. Because what this suggests, therefore, is that given a situation where you have previously established legislation from a previously established parliament that conflicts with a new piece of legislation, the court is bound, owing to this particular rule, to follow the previous legislation. Now, what this essentially means, therefore, is that Parliament is able, through the passing of the European Communities Act from 1972, to bind successive parliaments in the application of that legislation. And so, as a result of which, seems to take a view which goes against the traditional understanding of parliamentary sovereignty. Well, this is one of the major issues which is represented by this factor tame case. It essentially represents the disregarding of a principle of implied repeal. And this is only something which is resolved in subsequent cases. And these subsequent cases, such as Thoburn and Sunderland City Council, for example, are cases where it is established that there are certain pieces of legislation which have a potentially constitutional framework, i.e. are potentially constitutional in nature, and so as a result of which the application of implied repeal is something which does not apply necessarily to these pieces of legislation. We'll get to that in future lessons' time. In the previous lesson, what we did was talk about the impact of the membership that we had towards the European Union and the European Communities Act, the impact that that had on the traditional view and understanding of parliamentary sovereignty. And we came to the conclusion, therefore, from the case, the second factor tame case, that what it seems to be the case is that the idea of implied repeal doesn't necessarily seem to apply to certain constitutional statutes. This lesson is going to talk about another alleged constitutional statute, this being the 1998 Human Rights Act. And we'll talk about the sovereignty implications there before in the next lesson talking about the concept of declarations of incompatibility, again as it relates to the concept of parliamentary sovereignty. We explored the challenges of to the traditional system of parliamentary sovereignty, looking at the former impact of the membership towards the European Union, as well as hinting at the fact that there could be a delineation made between constitutional and non-constitutional statutory provisions. This lesson is going to talk about how the Human Rights Act from 1998 also presented something of a challenge to the traditional view of parliamentary sovereignty. So, the Human Rights Act was passed in 1998, and it would not fully enter into force until 2000. Some elements did, some elements didn't, but it was fully entered into force in the year 2000. Now, the general purpose of the Human Rights Act was to incorporate a number of the provisions, in fact, most of the provisions, of the European Convention of Human Rights, or on Human Rights, into the UK's domestic legal system. Now, for our purposes, the two main provisions of the Human Rights Act which are tantamount importance to us and have such an important impact on parliamentary sovereignty are Sections 3 and Sections 4. We're not going to spend so much time talking about the various and detailed implementations of each of the different rights that existed from the ECHR into the Human Rights Act. That is a topic for UK human rights law. So for now, we're just going to focus on looking at the two provisions here, Section 3 and Section 4. What Section 3 does is outline the process by which a court may be able to interpret legislation to be compatible with the Convention rights. What Section 4 does is outline the process where this may not be possible and the issuance of a declaration of incompatibility may be made. So let's begin first with Section 3. It says the following, It says that insofar as it is possible to do so, primary legislation and subordinate legislation, i.e. delegated legislation, must be read and given effect in a way which is compatible with the Convention rights. This section applies to primary legislation and subordinate legislation whenever enacted, does not affect the validity, continuing operation, or enforcement of any incompatible primary legislation, and thirdly, does not affect the validity, continuing operation, and enforcement of any incompatible subordinate legislation. If disregarding any possible revocation, primary legislation prevents the removal of the incompatibility. So, essentially, subsection 3, subsection 2 is not as relevant as the first provision. It says here that insofar as possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights. If we then look at section 4 says that subsection 20 applies in the proceeding in which the court determines whether a provision of primary legislation is compatible with the Convention right. If the court is satisfied that the provision is incompatible with a Convention right, it may issue a declaration of incompatibility. If the court is satisfied that the provision is incompatible with a Convention right and that the primary legislation concerned prevents the removal of incompatibility, it may make a declaration of incompatibility. So what do these two provisions essentially mean? Well, section 3 says that if you have a case which involves looking at a piece of legislation that is passed by Parliament or a subordinate, maybe from devolved institutions as well, and you have to look at that piece of legislation, and you have to see whether or not it is actually in line with and compatible with the Human Rights Act. What section 3 tells you is that you should interpret, insofar as possible, that legislation to be compatible with the Human Rights Act. So let's say there is a piece of legislation and there are multiple ways in which you can interpret the wording of that legislation. There's only one way you can interpret it that is actually compatible with Human Rights Act. Well, then the court will have to, according to section 3, interpret that legislation in accordance with the Human Rights Act and in accordance with the Convention rights. That's what section 3 tells us. Section 4 says something different. Section 4 says if you have tried to interpret, essentially, the legislation, but you still come to the conclusion that the provision is incompatible with the Human Rights Act, then you may be able to issue what is known as a declaration of incompatibility. We will get to what this means in the next lesson, but we will talk about declarations of incompatibility in more detail. But for now, let's just think about a case that we have here, the case of RNA from 2001 that was heard by the UK's House of Lords. The defendant in this case was charged with rape and sought to question the complainant's previous sexual relationships under cross-examination. So this was a trial. This was a trial involving a sexual assault, specifically the rape of an individual, and the defendants and the defendant's legal counsel in this case wanted to bring the complainants to the stand, essentially, for cross-examination, and wanted to question the previous sexual relationships of the complainant under cross-examination as part of their defense. This was initially prevented under Section 41(3)(c) of the Youth, Justice and Criminal Evidence Act from 1999, and it was argued that this provision, and thus disallowing the cross-examination, were a violation of the defendant's convention rights, namely Article 6 of the European Convention on Human Rights, which pertain to their right to a fair trial. So basically the provision from the Youth, Justice and Criminal Evidence Act was said to be in violation of the right to a fair trial because it didn't allow the defendant to cross-examine the complainant on account of their previous sexual relationships. The appeal was allowed. When the Crown appealed to the House of Lords, however, it was held that the appeal would be dismissed, the Crown's appeal would be dismissed. They argued that, in interpreting Section 41(3)(c) of the Youth, Justice and Criminal Evidence Act, in light of Section 3 of the Human Rights Act, the question of admissibility was one pertaining to the necessity of the evidence's importance in the issue of consent. If the exclusion of such evidence would threaten the defendant's convention rights, then it ought not be excluded. So that's what the conclusion was in relation to the House of Lords. They dismissed the appeal made by the Crown, and they essentially wanted to interpret, specifically Section 41(3)(c) of the Youth, Justice and Criminal Evidence Act, in conjunction with Section 3 of the Human Rights Act. This case allowed the House of Lords to discuss the impact of Section 3 on the wording of parliamentary statutes to ensure, insofar as possible, the compatibility of the legislation. They say that in accordance with the will of Parliament as reflected in Section 3, it will sometimes be necessary to adopt an interpretation which linguistically may appear strained. The techniques to be used may not only involve the reading down of express language in the statute, but also the implication of the provisions. So, what this is saying, therefore, is that if you read a statute and you want to read it in conjunction with Section 3 of the Human Rights Act, you may have to do so in a way which may appear to be linguistically strained. You may have to stretch the meaning of the legislation a little bit. And in doing so, you can then allow it to be compatible with the Human Rights Act. It is only where it is impossible to see any kind of compatibility with the Human Rights Act in a piece of legislation that you then turn to Section 4, which is the issuance of a declaration of incompatibility. But what this passage here tells us is that it may be necessary to adopt an interpretation which is linguistically strained, which means that you have to there is a lot of leeway. The door is open to do quite a lot of interpretation and the sort of stretching and squeezing of the language that is used in a provision before you then turn to Section 4 of the Human Rights Act, something that we'll get to in the next lesson. In previous lessons, we've been talking about the various implications which can be had in relation to parliamentary sovereignty. So we talked about the traditional view of parliamentary sovereignty. We talked about the doctrine of implied repeal, which was established as a sort of result of parliamentary sovereignty, at least the traditional view of parliamentary sovereignty. And then we've gone and had a look at the various different challenges to parliamentary sovereignty. So, or at least the challenges to the traditional view of parliamentary sovereignty. This includes things like the idea of constitutional statutes, our previous membership to the European Union, and also the issue of human rights. We spoke about the Human Rights Act in the previous lesson. Now we're going to continue to look at one of the implications of the Human Rights Act, which is this idea of the issuance of declarations of incompatibility. So this is going to be exploring the second part of our inquiries into the Human Rights Act from 1998, looking at the constitutional significance of Section 4 of the Act, which is the provision which outlines the issue of declarations of incompatibility. This is not going to be a lesson specifically about UK human rights law. That's a series of lessons that we're sort of working on in the background, and we've uploaded and released a few lessons on already. But for the most part, we're going to be focusing on the constitutional significance, the concept of the Constitution in relation to this theory of parliamentary sovereignty. So as a general recap, let's have a look at what Section 4 of the Human Rights Act actually tells us. It says that subsection 20 applies in any proceeding in which a court determines whether a provision of primary legislation is compatible with a convention right. Don't forget, the convention that we are referring to is, of course, the application of the European Convention on Human Rights as codified into domestic law with the Human Rights Act from 1998. If the court is satisfied that a provision is compatible with a convention right, it may make a declaration of incompatibility. Sorry, it is incompatible with a convention right. It may make a declaration of incompatibility. If you remember back to the previous lesson, what Section 3 does is tell us that if it seems on its face that there may be an incompatibility, the courts ought to take an interpretation of the legislation which essentially aligns itself with the convention rights. So if you can interpret the legislation to mean something that would be in conjunction with and compatible with the convention, and then as a result of that, you may have to do so. But if you cannot, regardless of whatever interpretation you have attempted to try and utilize, then we go over and have a look at Section 4, which relates to the incompatibility with a convention right. We're going to skip Section 3 and just go to Section 4, subsection 4, should I say, that says that if the court is satisfied that the provision is incompatible with a convention right, and that the primary legislation concerned prevents the removal of incompatibility, then it may make a declaration of incompatibility. So a declaration of incompatibility isn't something that you can just throw out as a court. You have to do these other steps first. So you have to first look at Section 3, and you have to say, well, can we interpret the legislation, the provisions within the legislation, to be compatible within the meaning of the convention? If so, and in a lot of cases you probably can, then in that case, then we don't have to refer to Section 4. If we cannot do that, then we go over to Section 4, and if we are satisfied that the provision is incompatible with a convention right, and that the primary legislation concerned prevents the removal of incompatibility, then as a court we can therefore make a declaration of incompatibility. We can declare that the provision and the legislation that is passed by Parliament is incompatible with the convention as per Section 4 of the Human Rights Act of 1998. So, as I've mentioned, and as stated in the legislation itself, the idea of Section 4 is not something that can be utilised or ought to be utilised on a regular basis. In reality, the idea behind Section 4 is that it ought to be used as something of a last resort where the statute cannot be reconciled under Section 3. So Section 3 is really the first port of call, and then Section 4 is really where we can see no reconciliation within Section 3. We then move over to looking at Section 4. Let's look at some of the case law that's examined and explored this in more detail. So we have the case of R. and Anderson versus the Secretary of State for the Home Department. This is a case from 2002, and in this case the appellant had murdered an elderly man in the 1980s, okay? And in addition to this, he had also murdered a 35-year-old man in 1987. So he went on something of a killing spree, not specifically within the legal definition, but he went on something of a, he went around and killed two people, let's just say. He murdered an elderly man, and then 7 years later he had murdered somebody who was 35. The trial judge and the Chief Justice made a recommendation that the man serve a term of minimum 15 years for both of the murders. The Home Secretary had then set the term of 20 years under the discretionary powers they had had as per legislation, specifically Section 29 of the Crime Sentences Act of 1997. And the appellant appealed the decision, arguing that this discretionary power to set the term of 20 years, and as a result of which the power which is derived from Section 29 of the Crime Sentences Act of 1997, was a violation of his Article 6 Convention rights, namely Article 6.1 of the ECHR, which was the right to a fair trial by an independent and impartial tribunal. So Article 6.1 of the European Convention on Human Rights states that there is the right for an individual to have not only a fair trial, but a fair trial by an independent and impartial tribunal. The argument was that the Home Secretary, being a political appointment, a member of the Cabinet, having this discretionary powers to essentially set the sentence for 20 years under this discretionary authority, was a violation of this independent and impartial tribunal element. So the result of which, and it was held that there had been a violation of the Convention rights, and that a declaration of incompatibility could have been issued, and was as a result issued, under Section 4 of the Human Rights Act in relation to Section 29 of the Crime Sentences Act 1997. This is how the provision works, this is how the legislation works. Finally then, let's look at the case from 2003, the Bellinger and Bellinger case. Mrs. Bellinger was a transgender woman who was a signed male at birth, and she had been living as a woman for a number of years before she had made the decision that she wanted to go and marry a man. According to Section 11C of the Matrimonial Clauses Act from 1973, a marriage would be void if the parties are not, quote, respectively male and female. Now, of course, some of this legislation has changed and been updated. This was 2003, and we've seen quite a significant change in the law, in the development of the law when it comes to same-sex marriage. But at the time, we were relying on the 1973 legislation of Section 11C of the Matrimonial Clauses Act. Bellinger then sought to appeal to the House of Lords, and she made the argument that the provision of the Matrimonial Clauses Act was actually incompatible with one of her convention rights, namely Article 12 of the European Convention, and so as a result of which she was seeking the House of Lords to either, under Section 3, interpret the legislation in compatibility with the ECHR, or more positively, in her case at least, or what she wanted more, was for them to issue a declaration of incompatibility under Section 4 of the Human Rights Act. It was initially suggested that the marriage was invalid. However, the ECHR, the ECTHR, the European Court of Human Rights, made it clear in the European Court's case of Goodwin in the United Kingdom that it would be a violation of Articles 8 and 12 of the European Convention to not recognise the validity of gender reassignment in the context of marriage. And so, on application of the legislation and the case law that was established by the European Court of Human Rights here, it was the suggestion that marriage was invalid was essentially overturned. In this lesson, what we're going to do is continue to talk about the concept of parliamentary sovereignty and some of the potential implications which can be had in relation to said concept. And this involves us having a conversation about the idea that exists within sort of broader constitutional theory relating to the idea of constitutional statutes. We're going to talk in this lesson about what constitutional statutes may be, how they may represent something of a limitation on parliamentary sovereignty, at least a limitation on the doctrine of implied repeal, and then have a little look at some of the case law which tries to establish this principle. So, oopsie daisy. So, like I said, this lesson is going to spend some time examining one of the principles of the UK Constitution, which implies the existence of a hierarchy of statutes which may be passed by Parliament. And traditionally, we understand that this may represent something of a limitation on the principle of parliamentary sovereignty, because one of the things that the idea of constitutional statutes provides is something of a significant weight to the particular piece of legislation, such that it takes more than simply something like the doctrine of implied repeal to remove it, to repeal and replace said legislation. All of which implies that the principle of parliamentary sovereignty does not have this unlimited authority in the same way as the traditional understanding of sovereignty is. So as a basic recap, if we remember back to previous lessons, we had the second factor tame case, where the House of Lords had the issue of two pieces of legislation which were potentially in conflict with each other. These pieces of legislation were the European Communities Act from 1972 and the Merchant Shipping Act from 1988. Fundamentally, the factor tame case, just skipping all the way to the end, sees that there is a contradiction between the European Communities Act in relation to a violation of EU law in relation to the Merchant Shipping Act. Now, the reason they were in conflict is because the Merchant Shipping Act violated the law of the European Union, and so violated the principle of the European Community's supremacy as stated in the European Communities Act. And so, by extension of this principle, it also violated the European Communities Act. So you have something of a contradiction here. You have a piece of legislation which was passed in 1972, which is contradicted by a piece of legislation which is passed in 1988. Now, given a traditional approach to parliamentary sovereignty, and on application of the principle of implied repeal, one might think that the result would be the disregarding of the 1972 Act. If you remember back to the Vauxhall case, you remember that the legislation which was passed previously was the one that was disregarded and replaced by the piece of legislation which was passed subsequently. If we were to apply that exact same logic here, then the Merchant Shipping Act would apply over the European Communities Act. But the House of Lords decided instead to apply the former legislation rather than the latter. And so they essentially flipped on their head the principle of implied repeal. And so as a result of which, it begs the question as to whether or not we would grant, for example, the European Communities Act from 1972 some kind of special status which the Merchant Shipping Act did not have, such that even where there is a contradiction and where implied repeal may suggest that the European Communities Act be repealed, it doesn't, because of this special status which is given to this legislation. This is further discussed in the case of Thoburn and Sunderland City Council from 2002. In this case, we have another example where we see legislation which challenges the European Communities Act. Specifically, this legislation is the Weights and Measures Act of 1985. According to Section 8 of the Weights and Measures Act, it specified that the use of the pound was a metric, as a metric for weight would be illegal. Okay, Mr. Thoburn and others argued that the Weights and Measures Act impliedly repealed that of the European Communities Act. even though the Weights and Measures Act violated EU law and by extension therefore violated the principle of supremacy as stated in the European Communities Act. And this raises the question again. It puts the courts in quite an uncomfortable position, given the fact that you have another example of legislation which should surely impliedly repeal the European Communities Act, but of course you've got the previous examples of cases whereby you have legislation which does not repeal the European Communities Act, like the Factortame case. The court would dismiss this claim, the claim that the Weights and Measures Act impliedly repealed the European Communities Act, and they made it clear that the Weights and Measures Act could not impliedly repeal the European Communities Act. But what is more important to our argument here is it tries to give something of an explanation as to why the doctrine of implied repeal does not apply in this situation. And this is the important view which is suggested by Lord Justice Laws, who says that we should recognise a hierarchy of Acts of Parliament as if there were ordinary statutes and constitutional statutes. This gives rise to this question about constitutional statutes, and also this question of there being a hierarchy of legislation. What Lord Justice Laws says here, and we're suggesting here, that there should be some special class of legislation which could be considered of having the status of being quote-unquote constitutional in nature, and so the result of which may imply that the doctrine of implied repeal cannot be utilised in relation to these pieces of constitutional statutes, given the fact that if that was the case, then you would see a repeal of the European Communities Act. You'd probably see repeals of the Human Rights Act and the Constitutional Reform Act, etc., etc., etc. And so in relation to this, they make the argument that rather than allowing the legislation which is constitutional in nature to be repealed impliedly, in order for Parliament to change the law in that regard, it must expressly make it clear that that is their intention to do so. So it has to pass legislation which repeals the previously constitutional statute, rather than just impliedly repealed by way of contradiction. This suggests, therefore, that the doctrine of parliamentary sovereignty is not one which is completely unlimited, or at least that the principle of implied repeal is not completely unlimited. Parliament still has the ability to make and unmake any law they so choose. They could still repeal the European Communities Act, which they have done post-Brexit, but they don't do so, but they can't do so by implied repeal. So it suggests that parliamentary sovereignty is still safe, but this specific element of parliamentary sovereignty may not be. And so this may ask the question, okay, well, what are constitutional statutes? Well, this is where Lord Justice Laws cites further conditions. He says that there are conditions which could be given to an Act of Parliament to give them this certain degree of constitutionality, this view of having some kind of constitutional status. They say that that the legislation conditions the legal relationship between citizen and state in some general overarching manner, or enlarges or diminishes the scope of what we would now regard as fundamental constitutional rights. This is something of a relatively broad and overarching interpretation, but it gives us some idea of what kinds of pieces of legislation may be fit into this category. And I've cited some of them here. This is a non-exhaustive list because there are others that can be argued, and really it is up for the courts, and it is up for those who are either claimants or defendants in cases to essentially make the argument that the legislation is constitutional in nature. So it is up to the courts to essentially make this determination as to which statutes may be constitutional and therefore may be granted protection against implied repeal through this precedent established by Thoburn. So, for example, Lord Justice Law suggests the Magna Carta from 1215, the Bill of Rights from 1869, the Acts of Union, the Government of Wales Act, the Scotland Act, the European Communities Act, the Human Rights Act, all contribute to being constitutional statutes. And we can understand why, because they fundamentally deal with one of the two conditions that are cited in the previous slide. So if you think about it, they condition the legal relationship between the citizen and the state in some general overarching way, or they enlarge or diminish the scope of what we call human rights. Well, if we look at all these pieces of legislation, the human rights condition can be established by the Human Rights Act, by Magna Carta, by the Bill of Rights to an extent. Things like the Acts of Union, Government of Wales Act, Scotland Act, all relate to things pertaining to the internal domestic understanding of the United Kingdom. So, for example, devolution with the Government of Wales Act and Scotland Act. This constitutes a relationship between the citizen and the state. So too does the European Communities Act, which not only constitutes a relationship between the citizen and the state in that the citizen can then rely on the law of the European Union, but it can also be argued that it contributes to the enlargement of fundamental rights, owing to the fact that membership to the European Union also includes membership to the Fundamental Charter of Human Rights.